We cover the latest topics and trends making waves across the sport and chat with our industry's most prominent leaders so your golf business stays one step ahead. Welcome to Golf Business Live, powered by Club Caddy.
Here's NGCOA CEO Jay Karen
and owner of Augusta Ranch Golf Club and president of the PGA of America, Don Ray.
Hey, good afternoon, everyone, and welcome to this special episode of Golf Business Live, coming to you live from the law offices of McKenzie & Hughes in Syracuse, New York. Still brought to you by our friends at Club Caddy. Thank you, Jason and team. This is my very first Golf Business Live without the ham to my egg, Don Ray. So let's see how well the show goes. Guys, Harry and Taylor, if it goes super, super well, we may have to renegotiate Don's contract. We'll have to see how this goes, but happy to be here. So I traveled to upstate New York this week to bear witness to oral arguments conducted this morning in the State of New York Court of Appeals that involves a wayward tee shot at Cazenovia Golf Club in nearby Cazenovia, New York. So as a reminder to everybody watching, whether it's YouTube, LinkedIn, or whatever it might be sure to submit your questions in the comment area and I'll get to that. But yesterday, I walked the grounds a bit at Cazenovia. It was closed for the winter, as you can see there. You can see the snow on the ground, but I was able to hop out of my car and walk to the spot in question right here. It's the third tee box on the golf course. And kind of lay my eyes on it as a golfer and just kind of after reading all the facts of the case. And today, this morning, I was able to sit in the courtroom and watch the oral arguments in Binghamton, New York, which is about 70 miles from Syracuse. The Court of Appeals is normally in Albany, I think, but I guess they were moving around the state and they took up residence here in Binghamton at the Broome County Courthouse here. So I was able to be there this morning. And I nodded my head a lot. I shook my head violently when I disagreed with the plaintiff's attorney. I was probably making a very nonverbal ruckus from my seat because I just could not help myself. It was such a fascinating case here. Each side this morning had 15 minutes, but really it was a barrage of questions from the judges themselves. And we're going to get into the particulars of this case and NGCOA's involvement and review what happened today and where things could go. And so we've invited onto the show here, partners here at McKenzie Hughes Law Firm. We've got Jennifer Caggiano and Brad Hunt. If you don't mind bringing them on, fellas. There you are. Hey, guys. All right, they're on mute right now, so let's make sure we get them off mute. Who has to do that? Harry, can you do that? We want to hear you, right?
Sorry, I think you have to unmute yourself. It's down in the bottom of the screen. My apologies.
Did we just break the fourth wall, Harry? Oh my gosh.
I don't exist.
There we go. Welcome to the show, guys. All right, looks like we're still having some delay issues. Can you hear us okay? All right. Sorry, folks. They're having some internet problems across the hall right now here at the...
Okay, how are you?
Maybe we'll come. They might be coming in here to join me. All right. Yeah, come on in here. All right. We're gonna handle this a little differently. We have got a backup plan here. We're gonna bring them into view here. I'm gonna pull my... Let's see if we can do this, guys.
Either side of you.
Yeah, either side of me, and you have to get close, okay? All right, come on in here. Sit close to me. All right. There's Brad.
Hello.
There's Jen. So,
hello, everyone.
all right. So, and this is going to be unusual, but I'm going to be asking them questions and talking about what I saw here. So, okay, let's bring this back up to the full screen. All right. Hey, guys. All right. Here we are. So I'm going to review what I think are the facts of the case, and then you tell me if I got my story correct here, okay? But please, if you don't mind, actually explain to the folks watching your individual roles here and kind of maybe before we talk about the facts, like you were the trial attorney and Brad, you were there today. Like, what did you do, Jen, and what did Brad do in this case?
So I'm the trial attorney. So when the initial lawsuit was brought and filed against my client, Cazenovia Golf Club, I handled it from answering the complaint and then conducting all the depositions, including of the plaintiff, the gentleman who claimed he was injured, We deposed the other gentlemen who were in his group. The gentlemen who were in the group where the errant ball was hit from, and then some folks from my client from Cazenovia Golf Club. Once all that was kind of completed, which is the discovery stage, we filed a motion to get the case dismissed. I wrote that motion in conjunction with, we retained an expert, two experts actually, a golf course architect and a PGA professional to assist us in our opinions. Plaintiff has an opportunity to oppose that. We argued the motions before a judge. This was a couple years ago, and despite my best efforts, the judge denied my motion. And so that was a bit of a rough day for me, but once we decided, well, we're not going to take that lying down, we filed a notice of appeal, and then Brad took over to handle the appellate papers after that.
Gotcha. And Brad was in court this morning and represented Cazenovia with the oral arguments. So
Gotcha.
yeah, so the facts of the case, as far as I can tell, and I've read the briefs and all that, it's fascinating reading, honestly. So Cazenovia Golf Club is a 9-hole layout, and it's one of the longest continuously running private clubs in America. Actually, it's been in operation for over 100 years. And the day in question was about 5 years ago. There was a member tournament going on, and I think they were playing the 9 holes 3 different times.
Correct.
In the tournament, and maybe from perhaps different tees each time to create that variety, as 9-hole operators usually have to do. So hole number 3, which is also doubles as hole 12, is a par 4, and it is straightforward. And to the left of number 3 is the approaching number 7 in the green, and it's kind of in a V shape from the 3rd fairway in tee box to the approaching fairway in green, and it's offset a little bit. So the tee is not like right next to the green. The green is down a little bit in that V. And I stood on that tee box. Are somewhat obscured. Well, one, because the green is a little elevated, so you really can't see the fairway. But this is not uncommon. I've been playing golf for 40 years, and standing on that tee box, I would have kind of viscerally felt, oh my gosh, how dangerous is the situation for someone on number 7, and it did not violate any sensibility that I certainly had. The plaintiff, Mr. Katleski, I think his name, he was on the 7th fairway in a golf car and was struck in the left eye. But what from what I assume was a pretty sharp kind of duck hook tee shot off the 3rd tee by a fellow member. He sued the golfer, and maybe even his playing partner, I think, was named when I saw, or someone who was playing with him.
So that was actually the golfer's, the ball striker's father. That was probably in an effort to rope in some insurance.
Okay. But that got dropped. That part, like the golf, somewhere along the line, they got.
But the 2 individuals were dropped, yes.
Yes,
So they
okay.
were either voluntarily, actually, I think they both won motions to dismiss.
Okay, but it left the course as really the defense.
Correct.
And a primary fact in question here, and this was really distilled down to really a few things, but was that about 15 years ago, a back tee was added to the 3rd hole set of tees, just a little bit further back. And I think it was, to create some variety, and if I walked it off, it's like 15 paces maybe from the old tee box that's still there. And the plaintiffs tried arguing that this new tee box created an unreasonable risk that is above and beyond what would be normally inherent risks in the game of golf. That's was kind of their primary argument. And that this newer tee box scenario led to questions about safety standards, what's practiced and what's not when design changes are happening, who's supposed to make them, what are safety standards. And the plaintiff seemed to be claiming that there are, and we really don't have agreed upon generally accepted safety standards for some of these things. What happened at that time of building that tee box. And the plaintiffs are arguing that the course was negligent and presented a dangerous situation enough to not be covered by the assumption of risk doctrine, right? And they argued, the defense argued that all this falls within the factors that are inherent to the game, and nothing negligent had been done. What am I missing? Is that kind of the overview of kind of what we're dealing with here?
No, I think you've got everything. The 2 courses, like the 2 holes at issue, like you said, are 3 and 7, and they are in a V pattern. There's actually, in fact, I believe 5 and 6 are in kind of where the bar would be if this was a capital letter A. So we've got this interplay of a very small, what maybe we would call a classic or historical course that's been around for over 100 years, built within the confines of the property, which was not a very large piece of property, but it's a very charming course, and I think that's why a lot of the local public enjoys it.
Well, today was fascinating. And so we already kind of explained that it's made its way up to the court system. And the Court of Appeals, is this kind of the highest court that this can go to? And what happens, and I'm going to jump to this question, but I'm going to get to some of my questions from the case. But where could this go after today?
So the Court of Appeals is the highest court in New York. It's basically, New York's version of the Supreme Court.
Okay.
And this is a New York law case. So this is the highest the case can go. So the two possible outcomes basically are either if we win the appeal, the Court of Appeals would be saying, we win summary judgment, the case is over, the plaintiff's case is dismissed. If we lose the appeal, the likely outcome is that the Court of Appeals says you need to have a trial. So you could kick it back to the trial court to actually have a trial in the case.
Okay. So let me ask you this, because I read 100 pages worth of briefs on this. Why were the oral arguments today important when everything that was really discussed even today in the half hour, nothing was new, right? So if all the judges had all the briefs, why was it necessary if really nothing new was discovered today?
There's a tradition that you can always have oral argument in an appeal, even though you're not introducing anything new in terms of evidence, and the legal argument should be in the briefs. But it gives you the chance to have your day in court, and it gives you the chance to answer questions from the judges. And as you observed, the oral argument is really mostly in this court, especially a question and answer session. So that's really what it's for, is for the judges to ask the lawyers whatever they want.
And by the line of questioning, because there were seven judges there, and by the line of questioning, I could tell who was a golfer and who wasn't, right? And at least 10 or 12 times I wanted to jump out of my seat. I felt like Scrappy Doo, let me at him, because there was, I felt just some basics that had some of them known, they probably would understand this a little bit more intuitively. Like, for example, one of the judges asked the question, and they're all good questions, but that because this was done in a tournament format, did that increase the risk? She said, were there like 20 balls flying in the air at one time that made, and the plaintiff's attorney made it seem as though the course is more crowded than normal, which would have raised the risk level. What did you guys say to that?
Those questions surprised me, first of all, because there wasn't really much in the papers to raise that as a legal issue. Although the fact that this took place during a tournament was part of the record. But my basic response to the questions today about the tournament was that no, that doesn't really change the fact that they were playing golf, and the risk here that led to the injury, being struck by a mishit, errant golf ball from the next hole over. That's a risk that's the same whether there's a tournament or not, whether it's a busy day at the course or a quieter day at the course. It really doesn't make a difference.
Mm-hmm. Another question that came up was about, and the plaintiffs made it seem as though a golf course would be responsible for going through some kind of safety assessment if they're ever going to change the course in any way. And this was an interesting thing, right? Because, providing a safe playing field is going to be any owner-operator's responsibility. If it's unsafe, they're not going to be in business very long. So, we're an industry where we don't have agreed upon safety standards in that sense, not like the construction industry might have or some others, because every golf course is different. So how does the course defend itself if they didn't fly in 4 safety experts or some local civil engineers that could look at the land and make a judgment on safety? Why is that an important, why is the plaintiff leaning on that as an important argument?
I think the plaintiff is leaning on that because the plaintiff's expert witness, Stephen Eisenberg, said in his report that there is a national, industry standard that you have to consider safety issues whenever you modify a course, and you have to do some sort of study or safety audit. And he he put that as his position in his paper. So the plaintiff's relying on that to create what lawyers call an issue of fact, which would mean a disagreement on a factual issue that a jury has to decide, that has to go to trial, basically. So our position in response is that really the disagreement between the parties' experts about whether there are industry standards like that is not material to the legal issue here, which is whether we created a risk, whether the golf club created a risk that's different from the normal inherent risk of golf. And the golf club did not create such a risk.
Right.
And we believe that's the dispositive point.
Okay, so it's funny because the golf club is Cazenovia, but we actually they discussed golf clubs and balls as well.
Yes.
Right? So there was mention of, or at least questions around the fact that this is a historic course, a classic design 100 years ago, and that technology has changed over time, that we use equipment that allows the ball to go farther, maybe faster, what have you, that plays into the increased liability when you're playing with modern equipment on a classic course. They were trying to imply that it's the course's responsibility then to modify the course as the equipment standards might have changed. Was there any, do you think that was effective?
I thought that was another interesting line of questioning that also really didn't come out of the briefs the parties had filed. That was new today. And those questions, it seemed to me, I wonder if you thought the same, seemed to come from a couple judges who did seem like they were golfers,
Yes.
I thought, and were familiar with golf. And they were really kind of pushing the plaintiff's lawyer today. So, okay, if this is such a problem, why didn't you sue the golf club manufacturers and the golf ball manufacturers also? Why should all the responsibility be placed on the course? And I didn't really hear a very clear answer to that. And in defense of the plaintiff's lawyer, this was new. She was kind of, they were taking her by surprise with those questions. But I thought that was kind of coming from a experienced golf angle, like, okay, sure, the new technology creates issues, but that's not just the responsibility of the course. That's also the responsibility of the manufacturers.
Also, and Jen, you and I were talking about this offline, that the USGA, who's generally the rule-setting body in our game, they've changed their technology standards over the decades. And unless I'm wrong, I'm not a golf historian, but every time they changed the standards, golf courses were not required to reassess and make sure that the golf course is now comporting to the new ball or whatever it might be, right? And so there's no historical precedent of golf courses feeling that the onus of doing that, right? So,
Correct.
And you're a golfer now, so you understand these things. But so in the way I was thinking about it was, this was a duck hook. This was an errant shot, and I bet people hit terribly errant shots with persimmon woods back in 1972. As they do with the modern technology. So while that was an interesting question, I don't think it really caused any additional liability for Cazenovia in this case.
I don't think so, Jay. And this course was, of course, constructed in the 1920s. So, if Ben Hogan had played it, this could have happened just the same as the ball striker here, who was a young man of 25 years old, and so probably striking a lot harder and farther than certainly I could do, and probably harder than some of the professionals in the 1920s with the technology. But the idea of, we have this golf as a self-regulating industry, right? Mm-hmm. And it's not like the U.S. government oversees it. There's not some other type of agency that says this is how you're going to run things. We trust that people that are professionals in the industry are going to know how to conduct it safely, but make it appealing to the public. And we all look everything under the lens of reasonability, and that's really what negligence is about. And it's just not reasonable to ask golf courses to consistently have to modify, upgrade, make these changes, which could be inherently costly and counterproductive to the sport if we're just going to try and keep up with the times of technology. That technology is moving much faster than design is going to move. So it's just not reasonable to impose that kind of burden on golf course operators.
Yeah, I agree. Guys, I'm going to get you to surface the comments because I can't reach my iPad now since we kind of changed the setup. Okay, so Dave Barton, good friend of ours, says, were course architects who typically design with flow and safety in mind involved in the new tee box creation? How far from the tee was the gentleman hit?
So there was not an architect who was involved with the modification. The gentleman, when he was hit several hundred yards from, or maybe about 100 yards from the tee box. So he was on the 7th fairway. And when I say this is 1 in a million shot, it is 1 in a million shot. I probably have a better chance of getting another hole in one than this ever happening again. Because he was in a golf cart and moving at the time that he was struck. We did engage our golf landscape architect, Barry Jordan, who's a local in central and upstate New York, and he had visited the site multiple times. He looked at where the plaintiff was when he was hit. He looked at where the ball striker was, and he determined that, hey, look, if they gave me a call and I came up here and they were like, hey, we want to put the tee box here, is this going to be safe for our golfers? He would have said no problem. In fact, this is going to actually make it safer for anybody who's golfing in those 2 holes that are, I believe, 5 and 6 in between 3 and 7. So even though there wasn't that proactive decision, the retroactive viewpoint was that wouldn't have changed the decision to add the tee box.
Okay. Surface Steve's question, if you don't mind, Steve Fluke. So he says, players understand that there is a general inherent danger of playing on any golf course. How can they expect to win a lawsuit against a golf course? So maybe paint the picture for what, I mean, these will all are complicated, but paint the picture for what would make for a negligent situation for a golf course owner.
So, I mean, a very outrageous example would be, you're a golf course and you leave a pit of nails on your golf course and someone steps into it, right? That's not a risk that's associated with golf. The one case I can think of, Brad, that comes to mind that plaintiff did use at some point in their papers was a course had constructed some type of retaining wall that was too close to the tee box so that when a mishit happened, the ball would bounce off the retaining wall and back at the ball striker or somebody else. That was kind of the closest case I can think of where you had a missed hit or something where someone was actually injured and they found liability. That case is different because we have a structure that was created that really has nothing to do with the sport and increase the risk that someone was going to get hurt, as opposed to here where we have, straight old mishit just based on the natural topography of the course. So it really, in our experience looking at the cases, it has to be something that has nothing to do with golf. A golf course, just like any other property, is still susceptible to a slip and fall accident that maybe has to do with some substance or dangerous condition, the steps are broken, things like that. But as far as golf course play, it's very limited because of the assumption of the risk doctrine.
So both plaintiff and defense used expert testimony along the way. And if I'm operating a golf course today and I'm following this case, I can see the importance of that testimony on either side. And is there any value in bringing in someone and recording that this happened, bringing in a golf course architect or someone, say, hey, can you just take a look? Look at my land, my 200 acres of golf course here, and tell me if there's anything here not inherent to the game, unreasonably risky, or anything like that. Is there any value in golf course owners taking that step, even if they're not being sued, just to have that awareness of someone to have on record that says, nope, you're good?
You may want to talk to your insurance company before you do that.
Yeah, I mean, look, obviously it could potentially help, but I do think if you're going to do that, you need to be sure that if any risks are brought to your attention, you follow up on them, because then if you don't, you've created a record that would be harmful, if something ended up happening.
So maybe don't do it unless you're prepared to make the fixes, right?
Right.
Yeah.
Right.
Okay. Fair. No, that's fair. Just saying, obviously, these without industry standards, these testimonies seem to have an outsized importance because we don't have standards to point to.
Correct.
So, one thing that, I noticed today is that the plaintiff seemed to, from my opinion, I'm a little biased here because, but
You're in the right spot.
Right, is the plaintiff seemed to have more challenging questions than you did. I mean, I'm sure you felt challenged for sure, but it just felt like she was getting peppered a lot more. And I don't want to say that they're trying to poke holes in everything, but is that, as lawyers, is that any kind of sign like, oh, that's kind of a signal that they're more sympathetic or they're just trying to understand? But it seemed like she got really more of the firing squad.
It's always dangerous to try to read into that, because sometimes the decision will end up surprising you. So, I would say as a general matter, if it seems like judges are being a lot tougher on one side than the other, that probably means they're leaning one way, but you never know for sure. And there's no way to be sure in this case or in another. Because again, part of the purpose of oral argument is just to let the judges, try to poke holes in the argument, and they may even do that to the side that they think is maybe right, just to make sure and think things through.
Right. Let's surface Harvey's question. Did the golfer who hit the ball yell for?
My favorite question, yes. In fact, not only did he hit the ball, yell for, the other three gentlemen that were in his group yelled for. My 2 points on that were, number one, that the plaintiff was some distance away. He was in a gas-operated cart, so for those of us that drive gas versus battery, they tend to be louder.
Yeah.
I do not believe he has hit the windshield down, although he was struck from the side, so I don't know if that would have made a difference. But he was also chatting with his partner seated in the passenger seat. So you had all these factors that probably eliminated his ability to hear anybody say for. But the law in New York does not recognize that you need to say for either to prove or disprove liability. It's just kind of a courtesy. So if the ball striker was still in the case and he didn't yell for, it doesn't mean, all right, we got you. That just kind of a fact that, as you can see from the question, people are interested in. It sounds good to hear if someone yelled for, but it really is not dispositive of any issues.
Okay. It makes me think also about music on the golf carts, because you mentioned gas versus electric, and it's becoming more ubiquitous to have your Bluetooth speakers, play music and all that. And I'm not asking for advice in this situation, but I'm telling the viewers maybe that could be another factor down the road sometime with some case that I didn't hear them yell for. The music, so is that going to be a signal to the industry, don't allow music on the golf cars anymore so that everybody can hear the warnings? I'm not saying that we should kill the music for that, but it's definitely been part of the evolution of the new field of golf is music on the golf cars.
Sure. Just like us driving in cars with our cell phones, it's probably something that may get policed at some point, but I think right now for the course operators, they're looking at it as, if I allow people to have their Bluetooth, they're more likely to golf here than not, so I'm going to allow it.
Okay. Let's bring up some more questions. The first one from Jason. There we go. Would additional signage or waivers help limit liability in situations like this?
It's hard to say for this specific example. I can say that my client does have signs on different holes when there is a pure blind shot. And by blind shot, we mean, I hope you all mean and understand that to be where you cannot see if people are within your intended path, which is not what happened here. So I think that certainly helps for a golf course if you have something that was very obviously potentially a hazard, is if you have some type of vision issues where someone is on the tee box and you can't see if someone's going to be in your intended path. Waivers of liability, they always kind of sound nice to have, but you can't waive away liability completely, even as a golf course, just because someone says, I know I may get hurt and I may, I understand there's a risk of getting hit and I'm going to sign this piece of paper and say that. That doesn't mean I show that to the judge and I say, case dismissed. It doesn't work like that.
Yeah, one other consideration I think on signs is that it's really possible at any hole on any golf course, if the shot is bad enough, it can go to the next hole over. True. So, you could conceivably, if you wanted to fully warn players, you'd have to have signs everywhere. And if you have signs everywhere, they kind of lose their meaning. So I think that can be a difficult question.
Bring up Gaylord's question here. I think this is a good one because a lot of golf courses will have high school tournaments and other things where they have spectators. It doesn't have to be a PGA Tour event to have spectators. And so what about spectators who are not golfers? Same standards apply in this case? Like, you can imagine the third hole here, you got spectators down either side of the fairway. They're now kind of in a danger of more, are they assuming the same exact risks as a golfer would be?
As soon as they're on the course, you're assuming the same risk. It's just, for those of us that maybe gone to baseball games, especially probably maybe about 10, 15 years ago with the nets going up, people being struck by foul balls, you weren't hearing about lawsuits brought by those people who were struck against the teams or the stadiums, because you're assuming that risk of foul balls may be hit, and you get warned, at the start of the game. So same thing for spectators. Again, the only time that maybe liability would apply is going to be if there's something that happened just over and above what is inherent to the sport of golf. And I'm trying to think of a situation, especially for a spectator, and I'm coming up kind of blank on that one.
It's a good segue. Let's bring up Jeff Schwister's question here. Jeff runs our Wisconsin organization. Were there any precedents you could refer to in this case? Has this type of lawsuit been brought up by a player ever before? I know you had other sports as well. Were there any golf cases?
Yes.
Okay. Can you tell what was used?
I used the case that I believe I was out of the second department, which in New York State would be mostly Long Island and Westchester County. And I believe this case was a Long Island golf course where almost the exact same fact pattern, where I had a ball striker on one tee. He hit a bad shot from into the adjacent hole, and the plaintiff was struck and injured. I actually cited that entire record in my initial papers to say to the trial court judge in Madison County, where this case is venued for potentially a trial, to say, hey judge, look, you've already had this case examined, adjudicated, and they determined there was no liability. So I used that as my kind of tent pole to say, I can make this very simple for you, judge. This has already happened. And you need to dismiss this complaint because we have precedent, and that's how the case law works in New York. The reason that probably didn't work at the trial level, my best guess is because that plaintiff in that case didn't have an expert to put forth any type of opinion.
Gotcha. So personally, I've been hit twice on the golf course by golf balls. Once was in the head, and it was just a kind of a one bounce on a cart path and beat me in the head. And it hurt. I might have, and then the second time was in the rear end. And I was walking up towards the green and I got hit. And it was in both times the group behind me, and they could see me. So in that situation, you're the golf course owner, and you let the golfers out on the course, and we all are spatially aware. We try to do our best, but I would imagine most cases of errant when a ball hits someone is probably someone hitting into the group in front of them. If that's the case, does that change the liability factor? Does now the golfer kind of take on the responsibility or the liability now because they hit into the group ahead of them that they can see?
Potentially, although there is a prominent case actually from the Court of Appeals, Non versus Kapoor, involved that situation and found no liability on the ball striker. And I believe what the court noted was that there could potentially be liability on the ball striker if he was intentional or reckless. But as long as it wasn't intentional or reckless in hitting the ball, then that was still deemed to be an assumed risk, even on the same hole.
Okay. And I found it curious today that neither the plaintiff nor the defendant were actually in court. And Cazenovia is not too far from here. To me, it's so consequential. Why would they not show up today?
It's totally up to the parties whether they want to attend, and it's not a trial where there are witnesses or anyone can give testimony. It's just a lawyer's argument in front of the judges. So sometimes parties will come, sometimes they won't.
Okay. And I'm going to close on a question with the last question with Jason Pearsall there about, thank you guys. If the plaintiff wins, should course owners expect increased liability insurance premiums? And I'm going to ask you actually two questions on this. One is, it's really about the cascading effect of this. One is the insurance side of it, because if insurance companies around the industry hear about this, will they change their algorithms and figuring out what premium should be? And two, even though this is the state of New York, what kind of precedent might this set across the entire country? Explain the legal side of that.
Sure. So to answer your first question, Jay, what we're trying to do is exactly that, is to prevent any effect on the insurance industry in this regard. And that's why we sought an amicus brief from the NGCOA. And that was kind of a policy argument that we made in our papers to the Court of Appeals to say, by the way, judges, if you don't just consider the ramifications of what happens to the plaintiff and the defendant in this case. Think about what the ramifications are going to be to the golf course industry and then also to the insurance industry, and that could be problematic. So, I mean, can I speak to exactly what insurance companies are going to do? No, I'm not part of those conversations, but we certainly are trying to eliminate the possibility that if this case goes against us, of what the consequences will be. To your second point, as far as more of a national scale, the way our country obviously is structured is that, the states have their own kind of sovereignty as far as the laws of their land. So this case is in a New York State, in the New York State court system. So New York's laws are what are ruling the day here. The Court of Appeals is the highest court in the land, so whatever they decide is going to have precedent over all New York State cases. That doesn't mean that a court from a neighboring case or a state or out in California couldn't say, hey, I heard about this decision in the highest New York court, maybe we should take a look at that. And the question will be just how much weight, a foreign court would have, within your own state. So we're trying to hopefully avoid all of that, but it's always possible that another state could look at, even if the opinion goes our way as well, that may also help out a court in another state to say, we're gonna honor what assumption of the risk means, and we're gonna keep it the way either we have it or change it to what New York is doing.
Okay, that makes sense. I mean, that's one of the reasons why we leaned in, was the fear of the cascading effect of all of this, right?
Right.
So let's bring up Harvey's question as well. He said, how much is the plaintiff asking for? And because when I read the briefs, I was like, what does he want? I really can't tell here. So explain this particular situation.
Well, I don't want to get into the numbers too specifically here, because the case is still obviously within litigation. He's asking for a lot of money. The injury was pretty significant. So most cases like this go through insurance. So there is usually the insurance policy determines how much a plaintiff is going to be asking for.
Okay. Yeah. Okay. So I get that. So, which is interesting because I don't know what a typical liability coverage is for the golf course, but it's interesting to see how this is going to play out. So what now? Okay. So this happened, and in what way will we find out how the judges concluded?
So they'll issue a decision. What is unique, as far as I know, about the Court of Appeals is they will actually give me a phone call and give the plaintiff's lawyer a phone call, and you answer the phone. They say, "This is the New York Court of Appeals. I have your decision in the Katlesky versus Cazenovia Golf Club case," and they read you basically the last couple sentences of the decision that tell you who won or lost. And it's kind of an unnerving experience, because often this takes place months after you've done the oral argument. You've been working on 1,000 different things in the meantime, and you're trying to remember, wait, is my client the respondent or the appellant? And they they will actually announce it by phone, and then you can go on their website and get the written decision and see what they
so it's not like white or black smoke coming out of a chimney. We're all kind of watching. Is that what?
No smoke in this case.
Excellent. So, all right. Well, really, guys, this was super helpful. Thank you for being on Team Cazenovia here and Team NGCOA, and to everybody at home, thanks for tuning in. And we will keep the membership in the industry informed as to what next. So as soon as you guys get that call, please let me be the second call.
Absolutely, let you
call
know.
your client,
Yes.
and then call us, and we can report out the news. So appreciate your help. Thank you guys for being here, and we'll see you guys on the next Golf Business Live. Thanks, everybody.
Thank you.